So welcome, Mr. Chadwick. So I believe we'll proceed from where we had left. We had left from question number 45. Question 45 of the questions that were laid before the various judges for the position of a judge at the Court of Appeal jurisdiction. So question number 5, the CPR makes provisions for amendment of pleadings. What will you say in regards to this provision? So basically, the panel, maybe I can also stress the fact that whenever I'm reading a case law, because Albert, whenever I'm reading any question, because Albert, you have joined us now, the floor is always open for any member to comment something before I read out the answer. So we have read out question number 45 on what the CPR says in regards to amendment of pleadings. So maybe Albert, you can state what you have in mind, or Mr. Chadwick, before I proceed and read out the answers.
I go first, or?
Yes.
Okay, thank you. Even though I'm answering on my feet, I was not expecting that question. So in my knowledge or understanding of amendment of pleadings, the CPR provides that a party, especially the plaintiff, has an opportunity to amend their pleadings within 14 days of filing without leave, that is automatic. And if the respondent or defendant has filed a defense, the plaintiff has to seek leave before filing an amended document. And the third aspect that I know is that once pleadings have closed, both of the parties are not allowed to amend their pleadings without leave of the court. So that is the best I can answer from the top of my head right now.
Thank you. Mr. Chadwick, any information?
Okay, just to add on that, I hope I'm audible.
Yes.
So, as per my understanding, I think now when you're amending, first of all, you cross by a red line on the party that you are removing, and if you're adding someone, you underline with a red. So, and also you have to indicate the date that you amended the pleadings as well. And those are the rules of amendment that I'm aware. And if it's a further amendment, you are allowed to use a different color like a blue. And you indicate the date that you have done the further amendment. So
Thank you so much for your contributions. I can also read out what I had from my end, is that the civil procedure rules allow for amendments, 1, once without leave before close of pleadings, and 2, thereafter only with leave at any stage on just terms, including in limited situations after limitation has run, and the court may also order amendments on its own motion to determine the real issues. We have various governing rules to support our affirmance, where if you check Order 8, Rule 1 of the Civil Procedure Rules, provides that an amendment can happen without leave once before close of pleadings, and then an opponent can apply to disallow such amendment within 14 days of service. This is provided for under Order 8, Rule 2 of the Civil Procedure Rules. Then the other governing rule is that in Order 8, Rule 3.1 of the Civil Procedure Rules, an amendment with leave, this is pursuant to the court's discretion at any stage, and terms as to courts etc. can also be applicable. So even after the limitation has expired, leave may be granted where it is just, but only within the specific allowances in Rule 3 to 5. For instance, you can have correcting names, changing capacity, adding or substituting a cause of action arising from the same or substantially the same facts. This is provided for under Order 8, Rule 3, all the way to 5. Then you have amendment of originating process. This is provided for under Rule 3. So principles apply to originating summons, petitions, and originating notices of motion pursuant to Order 8, Rule 4 of the Civil Procedure Rules. Then you also have another rule on general power to amend, even suo moto, not after judgment or orders. So if you read Order 8, Rule 5, it gives the court the inherent power to amend suo moto, but not after judgment or an order. Then we have time limit to file an amendment after leave is granted. So this is within time given, or if none, 14 days, otherwise the leave will lapse. This is provided for under Order 8, Rule 6 of the Civil Procedure Rules. And then lastly is what Mr. Chadwick had indicated, the mode of amendment. You have endorsement plus the red ink marking and any other color where it is a further amendment. This is provided for under Order 8, Rule 7 of the Civil Procedure Rules. If you read the other question, when it comes to the Law of Succession Act, there is a deceased person who has died intestate. There are two administrators who went to court to apply for letters of administration. The court did issue the letters. They then discovered that there is a property which was left out. How do they go about this situation? So I also leave the floor open to any member to comment before I read out the marking scheme. So the court has duly issued out the letters to these administrators, and then discover that there is a property which has been left out. How will you go about this? Okay.
Can I?
Yes, the floor is open to any member.
Okay, if I may try, I think this is one of the instances when you can apply for summons for rectification of the grant. On grounds that some of the property of the deceased was left out during succession or distribution.
Okay. What if there is a confirmed grant in that situation? In fact, that is the other question that falls immediately after 46. So to avoid any exhaustion, let us first answer this question. So Albert, you have duly attempted and you have gotten the fact that you seek rectification of the grant. So you don't apply for a fresh grant. You apply in the same succession cause to amend or rectify the grant, and if already confirmed, to amend the certificate of confirmation. This is done to include the omitted asset, then if necessary, seek review or confirmation directions on distribution of that asset. What are the governing rules? If you read Section 74 of the Law of Succession Act, we have rectification of a grant and limited scope. So the court may rectify errors in names or descriptions etc. and it can alter or amend the grant accordingly. Then, if the omitted asset changes the substance, for instance, it is a new or additional asset, not merely a dismissed description, courts often treat it as requiring review or amendment of the confirmation orders rather than a pure Section 74 rectification pathway. Judicial interpretation, we have the case of John Mugodhi Kigori, where it stated that omitted shares were treated as rectifiable, where it is essentially correcting the schedule of assets without changing administrators. But some courts have stressed Section 74 to say that it is narrow and that adding a new asset is substantive and is better handled by review or the inherent power. So I deemed fit to go through the decision that gives a contrary view to the general norm. If you read the case of in re estate of Samuel Mureithi Mugambi, re estate of Samuel Mureithi Mugambi, 2023, the ratio decidendi was that the court found that rectification under Section 74 of the Law of Succession Act is limited to correcting errors in names and descriptions, not the inclusion of omitted assets. However, the court has jurisdiction under Section 47 of the Law of Succession Act and inherent power under Rule 73 of the Probate and Administration Rules to make orders necessary for justice. Further, Rule 63 of the Probate and Administration Rules imports Order 45 of the Civil Procedure Rules, allowing for review of orders in succession proceedings. The applicant demonstrated that the omission of land parcel Kirua Nkado 336 was due to lack of knowledge at the time of the original petition and provided evidence of ownership. As there was no opposition and the requirements for review were met, the court allowed the application, ordered the grant and confirmation of grant to be amended to include the property and directed that cost be in the cause. Okay, so to also read another case of in re estate of Benjamin Thiongo, alias Benjamin Thiongo, deceased 2025, the ratio decidendi was that the court held that while Section 74 of the Law of Succession Act and Rule 43(1) of the Probate and Administration Rules limit rectification to errors in names and descriptions, the inclusion of a new asset is a substantive change that ordinarily would require a review of the confirmation orders. However, invoking its inherent jurisdiction under Rule 73, the court found it just and proper to allow the rectification to include the omitted asset in the estate and direct its distribution to Sarah Wangari Thiongo, as all relevant parties had consented and no prejudice will result. The court emphasized that its inherent powers may be exercised to ensure justice is done and even where procedural rules would otherwise limit relief. So those were the key takeaways that the panel was expecting from a potential candidate to state. So when it comes to the practical steps on what is somebody raising up his hand, you're allowed to just unmute and address us.
Yes. Sorry for that. If I'm getting you right, is that whenever a property has been left out, the best way to approach court is by filing for a review. Even though in its jurisdiction, the court has powers to include that property even in an application for rectification. Or what does the jurisprudence bring?
Okay, I can state it directly this way. For rectification of errors, names and descriptions of properties, etc., where there is just some minor errors, Section 74 of the Law of Succession Act on rectification of a grant will duly apply. But where you decide that there is an omitted asset and you want the same to form part of the list of schedules of the assets, we have seen courts, some courts taking the angle that you should seek review or amendment of the confirmation orders. But we have also seen the courts invoking its inherent jurisdiction pursuant to Rule 43 of the Probate and Administration Rules, because it is in the interest of justice. But there is one angle that I want you to take, in that the other party had consented. What if the other party is not consenting to it? So we can see a position where if that will result to a prejudice on the other party, you will be directed to file an amendment or a review procedure, because we have seen an import of Order 45 of the Civil Procedure Rules to be applicable in the succession proceedings. That is a key takeaway that I can say it emanates from the decisions above. You can at times face a challenge or opposition by the other party.
Do we approach court by notice of motion?
You use a notice of motion because is a chamber summons a recognized way of instituting an application? Yes, the answer is yes. But in this situation, what does the Order 45 state when it comes to seeking review orders? What document will we use when we are approaching court under Order 45? Maybe I seek for your assistance.
But okay, I'm also aware hey, there's a lot of echo, Victor. Some sections
Okay.
or some parts of the civil procedure rules do not apply to the Law of Succession Act.
True. Then, what kind of application do you bring in this instance? Because you have been told directly that Rule 65 of the Probate Administration Rules imports Order 45 of the Civil Procedure Rules. So in this instance, I believe we will have to follow the Order 45 of the Civil Procedure.
Then another thing.
A notice of motion will suffice, right?
Yes, yes.
Yeah. I also take a similar stand. Yeah, I'll have also gone with notice of motion. But I've opened a decision. It is a ruling where the judge is saying that before me is a summons brought under Rule 63 of the Probate and Administration Rule, Section 80 of the Civil Procedure Act, and Order 45 of the Civil Procedure Rules. So that summons, is it a chamber summons or a notice of motion?
It's usually a chamber summons.
It's usually a chamber summons. So
nowadays, you can't face a very huge blow on technicality because all of them serve the same purpose.
What about the CLE?
Now, for the purpose of CLE, I really don't know if there's.
So we go with chamber summons.
Yes, yes. Okay,
We go with chamber summons.
I can say
Yes.
in practice that is the most common used application when approaching court for such instances.
Good. Thank you, Albert, for that. So I was to now read down the practical steps that a person will have to take. So do a confirmation search for the omitted assets, whether they are statements, bank accounts, and obtain proof it is in the deceased name. Then, in the same succession cause, file chamber summons for rectification or amendments, seeking for amendment of the grant if not yet confirmed, and or amendment or recall or reissue of the certificate of confirmation of grant if already confirmed, to include the omitted asset in the schedule of assets. Then you are to serve all beneficiaries and interested parties, file consents if distribution is agreed. If the grant was already confirmed and the omitted assets need allocation, also seek directions that the added asset be distributed by consent, or leave to file a supplementary affidavit or propose distribution for that asset for the court's approval. If there is a disagreement or entitlement to the newly disclosed asset, the court will usually require a review or valuation of the confirmation orders, not just a clerical rectification pursuant to Section 74 of the Probate and Administration Rules. So I believe with that argument we have summed up our discussion. So the next question was asking on, can confirmed letters of grant be amended? Can confirmed letters of grant be amended? Okay, because it is basically a repetition of what we were discussing, I can go directly to the answers. Yes, a confirmed grant can be amended, but only with tight limits. Minor errors can be rectified even after confirmation, while substantive changes that include introduction of new assets, new beneficiaries, and redistribution generally require review of the confirmation order, or in extreme cases, also revocation. Governing rules. We have Section 74 of the Law of Succession Act that provides for rectification after confirmation on minor errors. The court may rectify errors in names, descriptions, time, place of death, or purpose in a limited grant, and the grant of representation, whether before or after confirmation, may be altered and amended accordingly. Then, codicil discovered after grant. So a codicil may be added and the grant altered or amended even after confirmation. This is pursuant to Section 75 of the Law of Succession Act. Okay. Judicial interpretation. Section 74 is narrow. It is for minor or superficial errors. You cannot use it to introduce new beneficiaries or assets and distribute the estate. Those are fundamental changes. Then another interpretation of the courts is that if the change is substantive, e.g. on omitted assets after confirmation, the proper route is often review of the confirmation orders and not rectification under section 74 of the probate rules. So that is basically an answer to that question. Then if you read question 48, are there instances where you can amend the grant? So the answer is yes. It looks like this person was being asked repetitive questions. So yes, you can amend or alter a grant even after confirmation, mainly under statutory rectification for minor errors or to court-ordered variation of review of the confirmation orders where the change is substantive. So to prevent a lot of duplication in what we are discussing, I'll omit the additional information. Then question 49, what are the instances for rectifying a confirmed grant? So various circumstances we have. Rectification of a confirmed grant is only available for the narrow section 74 errors and errors in names and descriptions. We have errors in stating the time and place of death and errors in stating the purpose of a limited grant. It is not the route for adding new assets, beneficiaries, or changing distribution. So that is the key takeaway. Errors in names, errors in time and place of death, and errors in stating the purpose of a limited grant. Those can be accommodated pursuant to section 74 on rectification of grants. So including new assets or substitution of an administrator, this amounts to a substantive change and rectification is refused. Proper route, review, or other substantive application. What about misdescription of property? In a confirmed grant or certificate, this can be rectified. Omitted properties generally cannot be added via section 74. Yeah, so at least we have exhausted the same. Question 50, as a judge, what do you do when a witness runs hostile? That I can leave the floor to the members to attempt, then we read over the question and answer criteria. You are a judge, what do you do when a witness runs hostile? So this one appears technical. So if a witness turns hostile, you don't strike out their defense. You control the process. Consider an application by the calling party to treat them as hostile, give leave to cross-examine them, ensure the proper impeachment procedure is followed, and then evaluate their evidence with caution. What are the governing rules? What are the authorities to support the above procedure? Governing rules. Leave to cross-examine on witness who has turned out to be hostile. So the court, in its discretion, may permit the party calling a witness to ask questions that could be asked in cross-examination by the adverse party. This is provided for under section 161 of the Evidence Act. I can repeat because I had faced a reading technicality there. So section 161 of the Evidence Act allows the court to use its discretion to permit the party calling a witness to ask questions that could be asked in cross-examination by the adverse party. So you can be granted leave to cross-examine your own witness, pursuant to 161. So another angle is that if you read section 163(1) of the Evidence Act, impeaching credit including inconsistent prior statements requires the court's consent for the calling a party. So I beg to read this section verbatim because it appears to have a technical interpretation. So if you go to the Evidence Act, section 163, the title is Evidence to Impeach the Credit of a Witness. So it reads that the credit of a witness may be impeached in the following ways by the adverse party or with the consent of the court by the party who calls him. 1. By the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit. And B. By proof that the witness has been bribed or has accepted the offer of a bribe or has received any other corrupt inducement to give his evidence. And C. By proof of former statements, whether written or oral, inconsistent with any part of his evidence which is liable to be contradicted. Then D. when a man is prosecuted for rape or attempt to commit rape, it may be shown that the prosecutrix was of generally immoral character. So those are the angles where through you sitting as a judge, you can enter into a consent, you can give the consent of the court to any person. To the credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court. So the creditworthiness of a witness may be impeached by the adverse party with the consent of the court, by the party who calls him, by providing the four tests. This is applicable majorly pia in trial advocacy unit, where the unit attempts to focus on cross-examination rules and closing and opening statements. This is the angle that we will have to analyze when it comes to rules governing cross-examination. So key takeaway is that impeaching credits, including inconsistent prior statements, will require the court's consent for the calling party. So in this sense, you as the judge will give the court's consent. So the other position is that court's power to recall or summon witnesses in criminal trials were essential to a just decision. This is provided for under section 150 of the Criminal Procedure Code. The same, I'll also read the same verbatim. If you read section 150 of the Criminal Procedure Code, it reads power to summon witnesses or examine person present. A court may, at any stage of a trial or other proceeding under this code, summon or call any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine a person already examined, and the court shall summon and examine or recall and re-examine any such person if his evidence appears to it essential to the just decision of the case, provided that the prosecutor or the advocate for the prosecution or the defendant or his advocate shall have the right to cross-examine any such person, and the court shall adjourn the case for such time, if any, as it thinks necessary to enable the cross-examination to be adequately prepared if, in its opinion, either party may be prejudiced by the calling of that person as a witness. So that is also another angle where we see that the judge can exercise its power to call or to recall or summon a witness that appeared to him to be a hostile witness. Okay, so judicial interpretation for us to understand. So proper handling is a trial court discretion issue. Declaring a witness to be hostile and permitting cross-examination under section 161 is lawfully where justified. Then the court must follow the correct procedure. Hostility is typically raised during examination in chief once contradictions emerge. A witness should get a chance to address inconsistencies. Even if treated as hostile, the evidence is not automatically worthless. It remains admissible but is approached cautiously and usually needs corroboration for weight. This was also determined in a decision known as Edusei Asili Malema versus Republic. Edusei Asili Malema versus Republic 207, where the ratio decidenda of the court was that the Court of Appeal found that the trial judge erred in law by not following the correct procedure in treating Faith as a hostile witness, as her credit was not impeached and her evidence should have been evaluated. However, after independently re-evaluating the evidence, including that of Faith, the appellate court concluded that the prosecution's case was credible and the trial court was justified in disbelieving the defense. The evidence supported the finding that the appellate assaulted the deceased and fabricated the robbery story as a cover-up. The conviction for manslaughter was therefore proper and the sentence imposed was lawful and merited. The appeal was dismissed in its entirety. So those are examples of how various courts have decided to interpret the provisions that will render a person to be a hostile witness. So there are some practical steps that you can take away what you do on the bench. So require a formal application by the calling party to treat the witness as hostile or record the basis if raised orally. So now you are sitting as the judge. Then satisfy yourself there is a basis, e.g. a witness resides from a prior statement, shows deliberate untruthfulness or partisanship, mere unfavorable evidence is not enough. Then you have to grant leave under section 161 and control questioning, no harassment, relevance and fairness. If prior inconsistent statement is used, ensure the proper impeachment method is followed, identify the inconsistency, put it to the witness, allow explanation, and then decide the weight. Then 5, allow the other side to cross-examine fully after hostility is declared. Then you as the judge, you ought to consider calling or recalling other essential witnesses under CPC section 150 if the turn affects the just decision that you are about to make. Then 7, in the judgment, warn yourself on the weight. Treat hostile evidence cautiously, rely on it only to the extent it is corroborated or a credible information is on the record. So those are the marks that the panel was expecting, because in this position you have been told that you are acting as the judge. So request a formal application, satisfy yourself there is a basis, grant leave under section 161. If there is prior inconsistent statement, allow room for explanation, then allow the other side to cross-examine the hostility, and then consider recalling other witnesses, and in the judgment take caution in such evidences unless there is corroboration. Then if you read question 51, can a counterclaim survive the withdrawal of a main
I'll go
suit?
to question.
Yes?
Can you address on the other witness? Usually, they're usually two. We usually have a hostile witness and a refractory witness. What happens to a refractory witness?
Okay, for that one I have not
At the
researched.
bench or at the bar?
Refractory witness. I'm relying on Google hapa. What happens in a position as a judge, or now a general?
Because I'm saying, okay, for a general oral
Okay.
session, you might be asked maybe to distinguish.
True.
Yes.
So the answer that I'm getting is that a refractory witness is the one who refuses to be sworn, or refuses to answer, or refuses to produce documents, or refuses to sign their disposition without sufficient excuse, can be committed to prison and the case adjourned in short blocks until they comply, without stopping the trial if there is other sufficient evidence. So refractory witnesses, the court may adjourn up to 8 days and commit the witness to prison unless they comply. If they still refuse on return, the court may repeat this cycle until compliance is obtained. This is provided for under section 152 of the Criminal Procedure Code. So it is an adjournment of 8 days in a circle until you comply. Then compellability or self-incrimination protection. A witness is generally not excused from answering relevant questions on self-incrimination grounds, but compelled answers are protected from being used against the witness except for perjury. Okay, so whenever you have been compelled to now release this information, that answer cannot be used against you except for perjury. This is provided for under section 128 of the Evidence Act. Then additional punishment may still apply. So the committal or adjournment power does not bar other proceedings or punishments for the refusal, and the court may proceed on other evidence. This is provided for under section 152.3 of the Criminal Procedure Code. So practical steps on what the trial court ought to do. You should warn the witness on the record and ask if there is a sufficient excuse for the refusal. Now you are sitting as the judge. If refusal persists, the court, you as the judge, now adjourn the matter for 8 days and commit the witness to prison, pursuant to section 152 of the CPC. Then on the next date, if the witness still refuses, repeat the adjournment plus committal in the same way, pursuant to section 152(2) of the CPC. Meanwhile, the court can still proceed with the case using any other sufficient evidence before it. Okay, so up to that point, I believe we have duly answered both angles on what happens to hostile and refractory witness in the two situations. So the other question was, can a counterclaim survive the withdrawal of a main suit? This one, I leave the floor to you members to attempt before we jump into the answer. Can a counterclaim survive the withdrawal of a main suit? Okay, proceed.
Thank you. Yes, indeed, a counterclaim can survive the withdrawal of a main suit. And the reason for this is because a counterclaim on its own, it is a form of a suit that is filed by a party in an already existing suit. So I'm looking at a situation where the plaintiff or claimant rather wishes to withdraw their main suit, and the defendant who had already filed a counterclaim raises some issues or a claim that can be heard independently without reliance on the main suit. The court will allow that party to prosecute their counterclaim, and the plaintiff will be allowed also to defend. And the same procedure that applies to the normal suit that is filed through a plaint, that is the normal procedure to going to trial, will apply now for the purpose of that counterclaim, and the court can deliver an independent decision on that counterclaim. Therefore, yes, it can survive. It doesn't mean that it is fully reliant on the main suit. If the main suit is withdrawn, the counterclaim can be heard and determined independently. Thank you.
Thank you, Albert, for that answer. And you have gotten the answer correctly. Yes, a counterclaim can survive withdrawal, discontinuance, or dismissal of the main suit and may proceed as a standalone cross suit. So, governing rules, we have counterclaim survives if the plaintiff's suit is stayed, discontinued, or dismissed. The counterclaim may nevertheless be proceeded with. This is provided for under Order 7, Rule 13 of the Civil Procedure Rules. We have also seen some judicial interpretation where the Court of Appeal, in the case County Government of Kwale versus Rahman and 5 others 2023, the court said that discontinuation of the main suit does not automatically kill the counterclaim. It remains independently maintainable under Order 7, Rule 13. Okay, so that was a straightforward answer with backed up with the enabling provisions of the law. So if you read question 52, what are the principles considered when granting security for cost? So I also leave this one to the members to attempt the same. What are the principles to be considered when granting security for cost? This one can be attempted as we read out the marking scheme. Any other member apart from Albert? Albert appears to be an active member, so that we distribute accordingly. We can allow the room to other members. Okay, proceed.
Okay, let me just try. I think you have to consider also the nature of the claim. If yeah, the nature of the claim.
Okay, any other test to consider before granting security for cost? Okay, then let us go to the marking scheme. Security for cost is discretionary. So the court balances 1, the defendant's right not to be dragged into unrecoverable cost against the plaintiff's right of access to justice, and will only order security where there is a real risk the plaintiff will not pay cost. Okay, so let us look at the governing rules, then I'll finalize on the threshold that the courts have consistently maintained. So the court's power, we have seen Order 26, Rule 1 of the Civil Procedure Rules, where the court may order security for all or part of the defendant's cost. Then 2, if there is substantial issue is which of 2 or more defendants is liable or apportionment, the court cannot order security. This is provided for under Order 26, Rule 3 of the Civil Procedure Rules. Then we have consequence of default, pursuant to Order 26, Rule 5, dismissal on application, and possible setting aside on sufficient cause. So those are basically the rules that are provided under the Civil Procedure Rules that touch on one aspect or another when it comes to security of cost. So how have courts interpreted this provision? We can say that this is discretionary, plus the court ought to take note of relevant factors where the applicant must show risk of non-payment or insolvency. This was seen in the Nakumatt Holdings case where they were going under. So we also have another interpretation on the burden is on the applicant. Mere fear or apprehension is not enough. So the courts must balance access to justice versus protection from unrecoverable cost, deny security where it would stifle a bona fide claim or where defendant's conduct contributed to the same. So what are the practical criteria the courts usually consider? These are the marking schemes. Sasa. 1. Ability to pay or risk of non-recovery. Okay, that is one. You have bona fides or merits indicator, whether the claim appears bona fide or is frivolous or vexatious or abuse of process. Not a mini trial, but the court won't ignore glaring weaknesses in your case. Then another factor to consider is access to justice and stifling its effect. Whether ordering security will shut the plaintiff out altogether, court may tailor the same. Then we have delay and conduct. We have timelines of the application, whether the applicant's conduct caused or contributed to the plaintiff's inability to pay. This will also be put into test. Then we have amount and proportionality. Security should be reasonable, often tied to likely tax cost, and can be ordered as deposit to be deposited in a joint account or bank guarantee. Then we have multi-defendant bar. If the real issue is apportionment between defendants, no security. So this can be asked as a standalone question where you have two defendants and the same is a real issue that touches on apportionment between two defendants, then you cannot be granted security. So this is also an important factor that people ought to consider. So this question was technical and required extensive mastery when it comes to security for costs in court. So if we move on swiftly, which legislation gives life to security for cost in Kenya? Which legislation provides for the life to security for Kenya? Again, open to the members before we reveal the answers. This is not technical, this is a simple one. What legislation provides or gives lives to security for cost application? And we have already mentioned the same. It is the main primary legislation. Order 26, Rule 1 of the Civil Procedure Rules, where a court may order security for the whole or part of a defendant's cost. That is the provision that gives life to security for cost. Okay. Then, is there an exception to the application of the doctrine of exhaustion? Open to the members. What is the exception to the application of the doctrine of exhaustion? Open to the members. What is the exception to the application of the doctrine of exhaustion? What if there is no alternative remedy provided in the tribunal, or if the remedy provided is not enough? Those are the some of the snippets that you should analyze. Okay, continue.
Okay, can I talk of also maybe the statutory limitations of time, let's say, assuming in a defamatory suit kind of situation, where you have a limit of 1 year and you can't really undergo the doctrine of exhaustion. Can it also that can be a point?
Okay, we have taken note of that. We'll read the marking scheme to see whether you fall under that exception. Any other member? Maybe to clear the air on the project work. Will you do an application to seek leave to extend time and then file the plaint on now defamation, or in the alternative, will you do a constitutional petition, or in the alternative, will you go under a negligence as a cause of action in your plaint? Those three situations, that is where a lot of groups encountered a challenge and would also like to know what is. I'm not saying that you disclose what you did, but do you have reasons why somebody should not follow a certain route and another person to follow a certain route? What is your thinking? Remember the Court of Appeal decision, when you want to seek extension of employment matters, the Court of Appeal has settled that matter and said that you cannot seek extension of employment matters. What is the rationale that is being borrowed from the Court of Appeal decision, and how is it applicable to the circumstances where you want to seek extension of time to something that has not been provided directly by the statute that you can seek extension of time to? Then, as you also think about that, also think of the decision, the Jimmy Wanjigi decision, the way it progressed all the way to the appeal stage, and this decision and this appeal was struck out. What are the mistakes that they did? Because it is a legal opinion that we will be giving this client, and the examiner expects to see all these kinds of discussion. Then we narrow down to the correct route that you will take pursuant to your group work. So you have clearly given us one exception, and we will subject the same to the marking scheme to see whether it will apply. So is there an exception to the application of the doctrine of exhaustion? The answer is yes. The exhaustion doctrine has a statutory exception. Courts may exempt a party in exceptional circumstances where it is in the interest of justice, and case law recognizes common triggers like an unavailable or ineffective remedy, or urgent or serious rights prejudice will arise. So what are the governing rules? Is that exhaustion is mandatory in judicial review unless internal or statutory mechanisms are first exhausted. This is provided under Section 9(2) of the Fair Administration Actions Act. Exception is where the court may, in exceptional circumstances and on application by the applicant, exempt exhaustion if it is in the interest of justice. This is provided directly under Section 9(4) of the Fair Administration Actions Act as an exceptional circumstance to the same. Then no exception unless you apply and prove exceptional circumstances, and the court is strict on this. Another point is that exemption where the internal remedy is unavailable or ineffective due to respondent inaction. So have you made any attempts? Did you receive any response? So those are the elements that the court will have to consider. If a clear statutory ladder exists, the court will decline jurisdiction absent exceptional circumstances, even where rights are pleaded. Okay, so what counts as exceptional circumstances in practice? This is what you will apply. Remedy is unavailable. There is no functioning forum. There is no committee. Time bar created by the state. A refusal to receive or act. So this is where Mr. Chadwick's point will indirectly apply. There is a time bar that has been created by the statute, and you want to go under the exceptional circumstances for the court to consider your application. Then where remedy is ineffective or illusionary, where the respondent delays so the mechanism cannot give timely relief. So this is why you will be exempted from the doctrine of exhaustion. Then you have urgency or irreparable prejudice, that the statutory forum cannot address it in time, must be evidenced, not asserted. For instance, if you have taken a complaint against the Advocates Complenary Tribunal, remember the tribunal does not have power to grant a stay of execution against you. So you cannot say you are going before the advocates tribunal, maybe they have found a judgment against you as the advocate, na huyu mtu anataka kuweka auctioneers to auction your property. Where do you seek the stay? You will be exempted from going under the doctrine of exhaustion, and in this case, because it will be an irreparable prejudice, you go direct to court and say, I'm exempted because of my urgency and irreparable prejudice. Then for pure constitutional question, where the alternative forum lacks jurisdiction to grant the constitutional relief being sought, still not automatic, you must show why the statutory route is inadequate. Okay. Then 5, procedural unfairness and bias. In the alternative forum, so serious that justice requires bypassment must be particularized. Okay. So the last 3 test, you must particularize pursuant to the facts given in the question, but we have seen the direct takeaway is where the remedy is unavailable and the remedy available is ineffective or illusionary. So those were the marking scheme. So if we go to this, the other candidate, Naima Sheikh Ahmed, is there a rule guiding the decongestion of prisons by High Court judges, as is the case for President under Article 133? Some questions were being framed in an awkward manner. So is there a rule guiding the decongestion of prisons by High Court judges, as is the case for President under Article 133? Maybe I give the room for people to try out as we read the marking scheme. How do you interpret that question? So by that silence, I presume. Okay, so the answer is no. There is no single prison decongestion rule empowering High Court judges to release prisoners the way Article 133 empowers the President under the power of mercy. A High Court judge can only reduce prison numbers indirectly through lawful judicial powers, e.g. bail, appeal, revision, resentencing, habeas corpus, and constitutional reliefs, not a general decongestion mandate. That was the direct interpretation of this question. Remember, there is a narrow High Court release power that exists. This is seen under Section 59 of the Criminal Procedure Code, where the High Court may order discharge of a person in prison for failure to give security upon report by a first-class magistrate. This is not a prison decongestion framework. So there is a narrow High Court power to release, being evidenced by Section 59 of the Criminal Procedure Code, that the High Court may order discharge of a person imprisoned for failure to give security. That is one of the angles, and maybe surprisingly, the panel was expecting the candidate to say this provision, because it also appears like an indirect power to release, to decongest a prison. How will you divide property between a husband who holds 70% of shares and a wife who holds 70% of shares in an LLP upon divorce? I also subject this to you members to attempt question 56. Question 56, how will you divide property between a husband who holds 70% of shares and a wife who holds 70% of shares in an LLP upon divorce? This was a current affair matter. Okay, proceed.
Okay, I think the pari passu principle will apply there. I'll divide equally among the partners.
That is well taken note of. We'll confirm. Any other person? Any other member who can attempt? So basically, I can read out the marking scheme. You don't divide LLP property 70 by 70 at face value. You determine each spouse's beneficial interest in the partner's LLP's interest and any other matrimonial property based on proven contribution, then give effect by valuation plus buyout or transfer if permitted, or sale of the partner's interest. Okay, governing rule: beneficial interest is pegged to contribution. This is provided for under Section 9 of the Matrimonial Property Act. Where property is not matrimonial property, but the other spouse contributes to its improvement, they acquire a beneficial interest equal to the contribution. Judicial interpretation: shares of an LLP or a company interest are distinct from the entity's assets. So the courts generally cannot share out business assets as matrimonial property. They can declare or quantify a spousal beneficial interest in shares or interest, or direct parties to the proper commercial forum for company assets. Okay, we have equality at dissolution is not automatic 50-50. Contribution remains key, monetary and non-monetary. This was seen in the decision PGM versus AWM 2022. Courts can declare a spouse holds shares in trust and award part of the shareholding, not the company's underlying property. So what are the practical steps that you should apply before answering this question, and how to implement when it comes to divorce? Fix the facts first. Our question has an arithmetic issue. In an LLP, or partners and profits ownership interest should total to 100% unless there are other partners or classes of shareholders. Confirm each spouse's actual partnership interest. Is it a partnership agreement? Do you have the LLP register and filings plus capital accounts? Identify what is divisible. Divisible in divorce cause: each spouse's LLP interest, economic value, in brackets, as acquired and accumulated during the marriage to the extent proven as matrimonial property or beneficial interest. Then what is not directly divisible? The LLP's assets, those belong to the LLP as a separate vehicle. Relief is usually via valuation or buyout rather than carving out LLP property. Then prove contribution, financial injunctions, loan servicing, unpaid labor or management, domestic work, enabling business, and guarantees etc. Court will apportion beneficial interest accordingly. Then monetize and exit cleanly. Jointly appoint a valuer or accountant to value each spouse's partnership interest. What is the capital account plus goodwill where appropriate. Then seek orders for buyout of the other's beneficial share or transfer if the LLP agreement permits, or as the last resort, seek for realization and sale of the interest. So basically, we have seen a decision that tried to divide the same. So if you read the case of SMK versus TWM 2024 decision, where the court found that only land parcel number Kiamba Kanunga and land parcel number Ndumberi Riabai were proven to be matrimonial properties, as both were acquired during the marriage and registered in the joint names of the parties. So the respondent failed to provide sufficient evidence of ownership, acquisition during marriage, or contribution regarding other properties, e.g. company assets or funds. Company property is not subject to division in matrimonial proceedings unless shares are properly claimed in the commercial division. The court applied the principle that division of matrimonial property is based on contribution, including non-monetary contribution such as companionship, caregiving, given the applicant's willingness for equal division and the respondent's role as wife and the mother. The court held that equal division of the two proven matrimonial properties was fair and equitable. All other claims were dismissed for lack of proof or jurisdiction. So we can say that courts, when the succession court is when a family court experiences the same issue before it, the issue on shares it appears to have a commercial division aspect because it also entails buyout provisions and various valuations so that the interest, beneficial interest, could first be determined, then taken back to the divorce cause. That is the key takeaway that I am able to deduce from this question, because a direct 70-70 share out is what the courts have declined in such situations. Okay. What is your opinion on the Methodist Church versus Buchikira Supreme Court decision? So this was asking on a landmark decision. It expected a candidate to have read this decision. Do you have any member who had tried to read this decision? Because from my end, I had not read this decision, and I could have skipped this question. Maybe I do a quick search. Let me do a quick search. So the basic answers that I'm able to deduce is that the Supreme Court decision in Methodist Church in Kenya versus Mohamed Fugicha and 3 others is often discussed in relation to religious freedom and school uniform, is primarily criticized by legal commentators for elevating procedural technicalities over substantive human rights. Okay, so that is a brief answer that I'm able to extract. Okay, the other point that I can also retrieve is that the Supreme Court's power to review its own decision is extremely narrow, only on the recognized grounds on fraud or deceit, nullity, mistaken belief of consent, reliance on a repeal law, or concealed statutory provision. It is not a backdoor appeal and cannot be used to re-argue the merits. So in Fugicha, the applicant failed to meet those review grounds, and the court treated the motion as an attempt to litigate and dismiss the same with costs. Okay, so we can say that this decision merely decided to promote, to elevate procedural technicalities over substantive human rights, but I beg everyone to have a look at that decision. I've found a summarized version of the same, where the Supreme Court held that its power to review its own decision is strictly limited to the grounds established in the Outer Case and Section 21(4) of the Supreme Court Act on fraud or deceit, nullity, mistaken belief of consent, or reliance on a repeal law or concealed statutory provision. So the applicant failed to demonstrate that any of these conditions were met. The court emphasized that review is not a substantive for appeal, is not a substitute for appeal, and that the applicant was effectively seeking to appeal the earlier decision under the disguise of review. The court reiterated that important constitutional issues such as the right to wear hijab in schools must be properly instituted and canvassed through the judicial hierarchy before reaching the Supreme Court. So the application for review was therefore dismissed as unmerited, and the applicant was directed to bear the respondent's cost. The dissenting opinion argued for a broader or value-driven interpretation of the Constitution, favoring substantive justice over procedural technicalities, but this view did not carry the majority. So the panel was testing on the candidate's power to interpret the obiter dictum and the dissenting opinion and the ratio decidendi from the case, and where the point of conflict arose, and we saw a substantive justice vis-a-vis procedural technicalities on the angle of the Supreme Court power to review its own decisions. That was the key takeaway in Fugicha versus Methodist Church in Kenya 2020 decision, a landmark decision that can be asked in our orals. Then if you read question 58, two Muslims contract an Islamic marriage. How should they go about divorce when 1. The man converts to Christianity and B, woman converts to Christianity. Give the two scenarios and how they should go about divorce when faced in such circumstances. This is also subjected to the members to try out before we read the marking scheme. Any person who can attempt this one. Two Muslims contract an Islamic marriage. How should they go about divorce when the man converts to Christianity and when the woman converts to Christianity? Any member? Okay, what are the answers? If the husband converts to Christianity, the divorce should still be processed as an Islamic divorce, so the Islamic law will govern. But if both parties are no longer Muslims, they do not submit to the Qadhi's court and file transfer. The file should be transferred to the magistrate court family division or the high court for dissolution applying Islamic law. Okay, if the wife converts to Christianity, same analysis. Islamic law governs dissolution, but Qadhi's court jurisdiction only exists if both parties are Muslims and submit to the court. Otherwise, use the civil courts while applying Islamic law. Okay, so I believe we have tried as much as possible to answer what are the governing rules. Islamic divorce governing law. The dissolution of marriage celebrated under Islamic marriage shall be governed by Islamic law. This is provided for under Section 71 of the Marriage Act. Then, registration of Islamic divorce. Islamic divorces are registrable through the registrar. This is an administrative step after dissolution pursuant to Section 72 of the Marriage Act. Some judicial interpretations. Conversion can remove Qadhi's Conversion can remove Qadhi's court jurisdiction because Qadhi's court require all parties to be Muslims and to submit to that court. If a party converts and withdraws submission, the Qadhi's court no longer has jurisdiction and the matter can be transferred to the magistrate court for determination. Okay, there is a decision there known as CAO versus JAA 2022, where the court held that while the marriage between the parties was celebrated under Islamic law and would ordinarily fall within the jurisdiction of the Qadhi's court under Article 175 of the Constitution and Section 5 of the Qadhi's court restrict that jurisdiction to cases where all parties profess the Muslim faith and submit to the Qadhi's court. The applicant's conversion to Christianity and our explicit withdrawal of submission to the Qadhi's court means that the Qadhi's court no longer has jurisdiction over the divorce petition, so the applicant's constitutional right to freedom of religion and conscience entitles her to seek determination of the divorce in a different forum. Therefore, the divorce petition should be transferred to the Chief Magistrate Court at Milimani for hearing and determination. Up to that point, we have duly answered the question. So key takeaway: if both parties profess Islamic law and submit to the court, file the divorce under the Qadhi's court. If either spouse has converted and does not submit, seek transfer of the file to the magistrate court or the high court where appropriate, but plead that dissolution is governed by Islamic law pursuant to Section 71 of the Marriage Act. So that is it. That is it. Describe the criminal trial process. We duly describe this process pursuant to our oral session 1. You can revisit the same where we began, all the way from the complaint being raised, all the way to the post sentencing steps where a party seeks a revision or an appeal from the same. What happens when the accused person keeps quiet? This was also covered under our oral session 1, where we saw different aspects on interpretation, where the accused decides to remain silent and the implications of each step. Can one claim constitutional violations in an employment matter? you have also been given the decision Edwin Dandy versus the IG decision. I can also pose this question to the members to try out the same. Can one claim constitutional violation in an employment matter? And what is the general rule of the thumb when the High Court is faced with many issues and it does not know how to narrow down to the main issue? What is the test applied in such situations? We have also answered the test part, but now answer this one, whether a constitutional violation can arise in an employment matter. Any attempt? Even a yes or no answer will suffice. Okay, proceed.
I believe since you've said a yes or no answer can suffice, my answer is yes. A person can claim a constitutional violation in an employment matter because there are many the claim can be grounded on many constitutional violations, but I admit insofar as Edwin Dundi versus IG is concerned, I'm not aware of that case. So I'm looking at a situation where probably violation of fair labor practices, maybe the dignity of a person in that environmental setup has been violated, or maybe his right to privacy has been violated. One can bring, depending on the type of constitutional violation that will have been brought up in that matter. So it applies on a case-to-case basis.
Thank you, Albert, for that attempt. So the answer is yes, as you have directly stated. You can plead constitutional violations in an employment dispute, but one, you must file in the right forum. This is the ELRC, and the court will apply constitutional avoidance doctrine. This is where, if ordinarily employment law will grant full remedies to the grievance that this person is bringing before this court, a constitutional petition may be rejected as an abuse unless you show an exceptional constitutional dimension. So basically, ELRC has jurisdiction to determine employment and labor disputes and grant constitutional reliefs where the dispute is employment anchored pursuant to Article 162(2) of the Constitution as read with Article 165(5)(b) of the Constitution of Kenya 2010. In public employment, constitutional rights often implicated include fair labor practices under Article 41, fair administrative action under Article 47, and protection of public officers under Article 236 of the Constitution. How have courts decided to interpret these provisions? You may plead constitutional breaches, but the court may decline if it's really just a contract or employment act. This is where they have applied the constitutional avoidance doctrine. Okay, where the employer's action violates constitutional labor or admin standards, ELRC will grant declarations and constitutional remedies. Okay, forum point: don't file in the High Court. Seek the appropriate remedies before the ELRC. So that is the key takeaway. How do you tie it to the Edwin Dandy versus IG scenario? So file the case in ELRC, especially for police or public service disputes, then plead the constitutional right with precision and tie it to specific employment acts or omissions, disciplinary process, transfer or demotion, discrimination, victimization, and denial of hearing, then address avoidance upfront. Explain why statutory employment remedies are insufficient, e.g. systemic illegality, abuse of public power, discrimination, and violation of Article 236 protections accorded to public officers. Then what are the remedies that you will be seeking? You can seek declarations, you can seek certiorari where suitable, you can seek reinstatement and compensation, and consequential orders. Remember, we saw compensation is one of the appropriate reliefs that is provided for under Article 23(3) of the Constitution of Kenya. Those are the angles that you ought to take. keen of. Then there was the other question that was arising. The High Court is faced with a decision, not a decision, with facts that reveal various issues, and what is the test that the judge ought to take so that they can narrow down to say that they have jurisdiction to hear this matter. Whenever you have many issues arising, you apply what we call the predominant test, where the issue that is predominantly arising from the same can be summarily decided in the matter. Then you apply the constitutional avoidance doctrine to say that some of the issues arising herein should be determined by other courts. For instance, we saw the decision on shares of a company where the judge, the family court, decided for this matter, let the commercial division hear matters on commercial interest on shares arising, because the same parties have not yet clearly indicated their beneficial interest for my determination. Question 62, what is the Supreme Court interpretation on the application of general principles of international law in Kenya? You have been given a decision, the Mitubel versus KAA landmark decision. What is the Supreme Court interpretation on the application of general principles of international law in Kenya? This one is subject to you members. Any person who can attempt, to what extent will these rules be applicable to our Kenyan laws? This is a direct answer. Any attempt? So the Supreme Court in Mitubel versus KAA held that general rules and principles of international law and treaties can be used in Kenya, but only to the extent they are relevant and not inconsistent with the Constitution, statutes, or binding judicial pronouncements, and that the UN guidelines or general comments are generally soft law. This means that they are persuasive and not binding, unless they crystallize into customary international law or are expressly incorporated into our laws pursuant to Article 2.5 all the way to 6 of the Constitution of Kenya 2010. Okay. So a direct interpretation from the decision on the Mitubel case, we can borrow the ratio decidendi, where the court held that structural interdicts are recognized as appropriate reliefs in human rights litigation under Article 23(3) of the Constitution, and the courts are empowered to issue such orders to ensure effective remedies for violation of fundamental rights. The doctrine of functus officio does not preclude the issuance of interim or supervisory orders in appropriate cases, especially where the enforcement of social economic rights is at stake. The court clarified that international law, including treaties and general rules, forms part of the Kenyan law only to the extent that it is not inconsistent with the constitutional statutes, and that UN guidelines and general comments are soft law, serving as interpretative aids but not binding unless they have become customary international law. The right to housing is to be progressively realized, and while illegal occupation of private land does not confer rights, long-term occupation of public land may give rise to protectable right to housing, though not to title. The court found the eviction and demolition were carried out in breach of a court order and resulted in the violation of the appellant's rights, but the trial court's orders requiring the respondents to furnish policies and involved non-state actors were not of remedial benefit. The proceedings were remitted to the trial court for appropriate reliefs in accordance with the Supreme Court's judgment. So that is the answer that the panel was expecting. ADR, AJS in Wajir, constitutional limits on the use of maslaha in murder and sexual offences. Refer to the case of Mohammed Adu decision. What is your say to that? Should ADR, AJS be applicable to murder cases and sexual offences? What is the end? What is the justifiable reason why we penalize individuals? Is it so that the victim can get a remedy, or it is to the benefit of the state if this person is jailed?
Victor, I know you are an expert in that. Nishu kifika nayo kutoka ile
In fact, I wrote an article. Thank you. I did an article
I
with persons
remember you did an
to Thank you, Albert. So, if you check the application of maslaha, this involves the use of blood money, where if there is a murder case that has happened in a certain clan, then it is the clan of the victim together with the clan of the accused person. They will have a meet point. Then in this meet point, they will do an actual fine to the killer in quotes. Then and a number of camels will be declared to be given out. Then there will be a ritual to be performed, and then from that ritual, this clan and this clan will have formed now good blood to an extent where they can also recommend a person to marry now from that clan to seal that practice. But remember, we also saw it's not only applicable in Wajir Maslaha cases. I also saw in Ukambani region where there are two high court decisions that also applied blood money person to their Kamba traditions, and the decisions were never appealed, because if you read out those decisions, they directly stated that provided the family of the victims are in good terms now with a person who committed the same, and the same was not intentional, then they never saw it fit for the matter to proceed. But remember, the court stated that it is to be used sparingly, in that you cannot not only raise the same when the judgment is just about to be delivered. It ought to have arisen in the preliminary stages of a matter. So it's still under a hot debate discussion. Even Professor Kariuki Muigwa has tried to write on the same, but surprisingly there is no definite answer whether you should ignore ADR or AJS in such situations. So basically there was a memo that was written by the government of Kenya that now declared the Maslaha system to be unconstitutional, not unconstitutional. It was an executive statement to the communities there that they have banned the use of Maslaha when it comes to Sexual Offences Act, because we realize when it comes to sexual offences, the threshold now is higher, because you can result in infringement of human rights recognized internationally, because this child cannot have the voice to speak on his behalf. Remember, the murder cases are separate because it is the community speaking on your behalf. But in a sexual offences matter, the question that arose was, can a minor in his or her capacity be in a position to negotiate in his or her behalf? So that led to the same being declared illegal. So what we have seen is that if a community wants to practice maslaha, they just cross over the border to Somalia. They settle the same because Somalia has incorporated the same into its laws where blood money is recognized. So they apply the laws governing Somalia region, then they come back to Kenya. So we have seen that in various documentaries as I tried to write the article. So basically that is the key takeaway of what I can say in this situation. So the marking scheme
made in Somalia being held as
No, I'm referring to, because remember, it is not declared illegal by any law in Kenya. Okay, this was an executive directive that was sent to the communities there that banned the practice of maslaha and blood money. So what the communities now currently are doing, they are crossing the border. Unaona? They are applying maslaha law in accordance with the Somali culture and laws, so that once they return to Kenya, it is in a silenced mode. Everything has already been complied to, and the clans are okay. They are doing that to defeat the supervision of the chiefs located in those regions, because they know once they do it openly, they will be arrested. So that is how I saw the communities there trying to escape the application of the same. So maslaha or AJS can be used in Wajir and elsewhere only within the constitutional limits. It cannot override the Bill of Rights, cannot be used to privatize serious crimes, especially sexual offences, and cannot displace the DPP's constitutional mandate and the court's duty to ensure a fair trial and public justice. So if you read the Victim Protection Act, victims' restorative justice participation is voluntary and cannot prejudice the offender's rights. If it fails, then trial will proceed. So Wajir murder withdrawal based on maslaha and witness unavailability. We have seen a decision known as Republic versus Denu Lalafa Omar 2016, where the High Court permitted ODPP to discontinue murder proceedings where a clan or community maslaha settlement was reached and witnesses were unwilling or leaving no viable prosecution case. So in this situation, the clan decides now they will not appear on behalf of the prosecution, and that basically now tells you that the prosecution will not have any reliable source of witnesses or information. So similar approach in another murder file was seen in Republic versus Ado Isaac Kulo 2016, or where a similar approach in another murder file where reconciliation and compensation led to witness non-cooperation and court allowed discontinuance or discharge but not an acquittal. So this court was keen not to allow an acquittal but merely decided to discharge this person to maybe section 87, in that if there is any new evidence that is to be found, then it will be brought back. So limit emphasized. So reconciliation and compensation does not automatically justify diversion or discharge in murder. Absent exceptional circumstances, the court rejected diversion and pointed parties to plea bargaining. Okay, so there are times where if you read decision known as the Republic versus Mariko 2025, the court rejected diversion on grounds of compensation or reconciliation, and instead told the party to go to a plea bargain agreement. So that is where we draw the line. It is more of a debate answers compared to a definite answer. Then question 64, separation of powers, political question doctrine. What is the political question doctrine when it comes to separation of powers? Any person who can attempt this one before we answer? Okay, this one appears to be technical. The political question doctrine is the separation of powers restraint principle, where the courts will decline to adjudicate disputes that the Constitution commits to the political branches, for instance, the Parliament or the Executive, or that lack judicially manageable standards, for instance, rightness or justiciability, but they will still intervene where there is a pleaded constitutional breach, illegality, or procedural and non-compliance. In Kenya, the doctrine operates through constitutional allocation of functions and justiciability and rightness limits, not an express constitutional clause. The key practical point is that courts won't run parliament or the executive, but they will police constitutionality and legality. That is the answer to the political question doctrine in regards to separation of powers. Okay. So an example of this application was seen in the case known as Okoiti versus Ministry of Defense and another. It was a 2022 decision where the court declined to intrude into the executive or parliamentary policy choices on defense or national security, emphasizing justiciability restraint. We have also seen a decision known as the Tribeless Youth versus the National Assembly, a 2025 decision where the High Court struck out a petition challenging a bill still in the legislative proposal stages. Jurisdiction to test constitutionality is triggered against enacted law and not drafts in Parliament. So that is where you can apply the doctrine in a live example. Can judges participate in harambees? Conflict of interest. This is also pursuant to professional ethics, can judges participate in harambees? Any member who can attempt that one?
What kind of harambees are being contemplated here? Ile mchangisho.
Fundraising. Ya kuchangisha.
Oh, I believe judges are citizens of Kenya. Everyone has freedom of association. So unless it is an activity that will affect his neutrality in the course of his duties, I don't think there is any reason to deny judges opportunities or any other societal affairs, so long as it does not compromise his integrity towards his or her position or in her employment and duty. I believe they can participate.
Thank you, Albert, for that answer. Any other member before I read out the marking scheme?
Okay, also to add on that, I think just Wasame at some point hinted on his ambition to vie as a governor of Wajir. So I do concur with my fellow colleague that indeed judges are not banned as long as it will not affect the functions of his office, because if you see that they do not participate, they can still use their proxies to just donate money as well. So I do believe that they're really allowed to participate as long as it's not going to bring a conflict of interest in their functions.
So thank you for the combined efforts between Chadwick and Albert. So yes, the answer is yes, but only in...
There's another hand from Chebet.
Oh yes, you can proceed.
Can they really participate? Because I would have said no, they cannot participate. I think the same level of this guideline that prohibits MPs from participating in that. I would have said no, they're not allowed.
Okay, thank you for that.
That's prohibited.
There are some exceptions, and there is some interpretation of a certain law, particular section 26 of the Elections Act. We'll also have a look at it, because the answer was yes, but it had an exception, but only in a tightly controlled way. A judge should not participate in a harambe or fundraiser where their presence, role, or contribution can reasonably create or appear to create a bias, influence, or impropriety, especially where litigants, lawyers, political actors, or entities likely to appear in court are involved. The binding constrict is the Judicial Service Code of Conduct and Ethics made under the Judicial Service Act Cap 8A, which operationalizes the Bangalore principles on independence, integrity, propriety, and avoidance of conflict and appearance of bias. So the Supreme Court has affirmed that judges' private engagements with litigants and parties and other conduct creating an appearance of impropriety can amount to breach of the judicial conduct and justify removal. This was seen in the case of Chitembwe versus tribunal appointed to investigate into the conduct of himself, 2023 decision. So let me take the exact part that is applicable. The appellant's conduct engaging with litigants in private, discussing pending or determined cases, failing to disclose a relationship with a party, and acquiring an interest in property subject to his own judicial decision constituted gross misconduct and a breach of the Judicial Code of Conduct and Ethics. The court found that the audio and video recordings were lawfully obtained by participants in the conversations, were relevant, authentic, and did not violate the appellant's constitutional rights to privacy or fair hearing. The claim of entrapment was rejected as no law enforcement agents were involved. The standard of proof in removal proceedings is intermediate, and the tribunal's findings on all 6 allegations were supported by the evidence. The Supreme Court dismissed the appeal, affirmed the tribunal's recommendation for removal. Then another decision known as Evans Misati James versus the IEBC 2012 ratio decidendi was that Section 26 of the Elections Act 2011, which prohibits prospective candidates from participating in harambees within 8 months preceding a general election, except for political purposes, is a reasonable and constitutionally permissible limitation on political rights. The provision is aimed at preventing the undue influence of money in politics, promoting fair and free and fair elections, and ensuring integrity in the electoral process. The court found that the differentiation between candidates and ordinary citizens is justified by the need to curb the historical abuse of harambees for political gain and to level the playing field amongst candidates. The regulation of harambees is within the legislative mandate and does not violate social, economic, or cultural rights, as Harambee is a voluntary activity and not a state obligation. The petitioners failed to demonstrate that Section 26 is discriminatory or infringes on constitutional rights. The court held that the object of Section 26 is legitimate, rationally connected to the purpose of achieving free and fair election and is not unconstitutional. So, key takeaway is that Section 26 of the Elections Act prohibits prospective candidates from participating in harambees within 8 months preceding a general election, except for political purposes. Okay. So, do we have a definite answer to our question? So, practical guide on how you could have answered. Avoid harambees where attendees and donors include litigants, advocates, political actors, contractors, or anyone with matters before or is likely to come before the judge. No guest of honor, keynote, or public solicitation role. It amplifies perception of influence. If attendance is unavoidable, e.g. a close family or community obligation, keep it low profile, no fundraising role, and no acceptance of gifts linked to the event. Be prepared to recuse if a connected party appears. 4. When in doubt, decline. The risk is not just actual bias, but appearance of impropriety as treated seriously in the Chitembo decision. This is why when you invite a judge to give a lecture at a university, they don't accept gifts, and if it is an acceptance of a gift, they display the gift to the public. This is provided for under the Judicial Code of Conduct and Ethics. In fact, it is okay, iko hapa tutaipitia uzuri as a standalone regulation. So that was a technical question. Let us move swiftly to Conrad Mugoya Busiri. Section 83 of the Elections Act. In the 2013 election petition, the Supreme Court stated that Section 83 applies conjunctively. In 2017, they stated that the section applies disjunctively. Does this constitute a departure, and how should a court depart from a previous decision? I also leave it to the general public to make an attempt before we look at the answer. Does it amount to a departure? So the answer is yes. The 2017 interpretation on disjunctive nature is a departure from the 2017 framing on conjunctive nature. A later Supreme Court may depart from its earlier decision only by giving a reasoned justification grounded in correctness, constitutional fidelity, changed statutory text, or demonstrated unworkability, and it should do so explicitly, preferably via a larger bench when appropriate. So that is the answer. The Supreme Court can depart from its earlier decision provided it gives a reasoned justification grounded in correctness, constitutional fidelity, changed statutory text, or demonstrated unworkability, and it should do so explicitly, preferably via a larger bench where appropriate. This also begs a question. If the Court of Appeal bench, one of the person sitting in the bench is corrupted. What happens in such situations? So we have seen that the Chief Justice will disbar the whole bench, because corruption to one member of a bench amounts to corruption to the other members of the bench. But now what happens in situations where one member of a Supreme Court bench has been corrupted? Remember, the number is limited. You cannot go and fetch out any other judge elsewhere to replace this bench. That judge will be removed from the proceedings, and the remaining judges will have to sit on that matter, provided an odd number will still be maintained. So in this effect, they can opt to remove 2 so that we still maintain the odd number, or in the alternative, I don't know the alternative. Sijui the alternative. Mimi nilisikia hiyo mtu akijibu hiyo, but sijui a situation where it is only one who is to be removed, and then the number yenye inabaki ikuwe even number. What happens? Will now the dissenting or the majority provision apply to that situation? I don't know. Any member who has raised their hand?
Okay, just to inquire, I was requesting it if maybe you can read that section 83. Know what it's talking about.
Okay, let me read section 83 of the Elections Act. It talks on nullification of an election. A court shall not declare an election void for non-compliance with any written law relating to that election if it appears that 1. The election was conducted in accordance with the principles laid down in the Constitution, and in that written law there is a semicolon and the word "and". B. The non-compliance did not substantially affect the result of the election. So this is what resulted in a conjunctive approach and then a disjunctive approach, where the Supreme Court departed from its earlier decision. So maybe to put it into test is that conjunctive meaning, how the same was applied, petitioners had to prove non-compliance and that it affected validity and outcome. So the two-limb burden had to be proved. That was back in 2013. But in 2017, the court took another stand where the court held Section 83 is to be read disjunctively. An election can be invalidated either for substantial non-compliance with constitutional principles or if irregularities affected the result. Okay, so the Supreme Court has since reaffirmed the disjunctive element of it in another decision known as Combe versus Carissa 2024. This is also a landmark question where many candidates were asked whether they knew of the Combe versus Carissa Chengo decision. This is it. So how should a court depart from its previous decision? Acknowledge the earlier binding decision and identify the exact point of conflict. That is 1. Step number 2, justify the departure with a principled basis, typically one or more of the following: correctness or constitutional fidelity. You can state that the earlier approach is demonstrably wrong or inconsistent with the Constitution or statute. The other angle is that statutory change. Parliament amended the governing text. Relevant here is because Section 83 was amended in 2017. So if Section 83 was later amended in 2017, then the Supreme Court was competent to depart from its earlier decision because there is a statutory change in effect. Then unworkability or uncertainty. Prior test has proven unworkable or produces injustice or incoherence. Remember the Murwatetu decision 1 and Murwatetu decision 2. If the same had proven to be unworkable, there could not have been any clearer interpretation of the same. They could have departed from the earlier decision pursuant to unworkability and uncertainty of the earlier decision. Those are the tests that you have to apply. Then you state the new rule clearly. Is it to be applied prospectively or retrospectively? then institutional prudence, where the issue is fundamental, or constitute an expanded bench and explain why finality or consistency is served by correction. That is the threshold. So in this sense, Karisa Chengo, then the Elections Act decision 2013 Raila, 2017 Raila, we have borrowed the takeaway, and we are now competent to answer such questions. How are advisory opinions of the Supreme Court enforced? This is another question. How do you enforce the advisory opinions of the Supreme Court of Kenya? Any member can attempt. Any attempt? This is a technical question. Advisory opinions of the Supreme Court are enforced through politically and administrative mechanisms where there is compliance by the requesting state organ and other public bodies, and juridically where courts will treat them as authoritative guidance and can police non-compliance through ordinary constitutional or JR litigations. They are not executed like decrees via attachment. Okay, so they are enforced politically through administrative means. Yes, you can speak.
Yes, thank you.
Thank you, Victor. How are they sought in the first place? How does one move the Supreme Court for an advisory opinion? What do you file, or how do you move the court?
Basically, I know that advisory opinion jurisdiction is governed under Article 163(6) of the Constitution of Kenya, and it is usually issued at the request of the national government or any state organ or any county government on matters concerning county government. So that kwanza answers how you seek for advisory opinions from the Supreme Court. So the other key takeaway is that advisory opinion jurisdiction is discretionary and meant to guide state organs on governance questions concerning counties. The court exercises restraint and does not use it to resolve ordinary disputes. Where the court does not give an advisory opinion, it is intended to settle legal uncertainty and guide government actions, not merely the applicant. So that is what I have from my end, unless Albert, you want the exact application that you draft before the Supreme Court when seeking the advisory opinion.
Exactly, yes, that's what I wanted to confirm. You file a petition or what?
I'm also not clear unless I Google. Let me Google the same. Let me type.
I've seen, I think you found a reference.
A reference to this?
Yes, yes.
Okay. Later.
Then you seek the issues that you want the Supreme Court to give an advisory opinion on.
Wow, thanks Albert for that answer, because what I have from my end imetoa answers to what the usual application that is to be filed when you are seeking now the enforcement compliance to a state organ after an advisory opinion has been granted. So you go under constitutional petition pursuant to Article 22 and 23. So this is used when the impugned act or decision is unconstitutional and violates the Constitution as clarified in the advisory opinion, or you seek the following orders in that constitutional petition. You seek a declaration, you seek conservatory orders, you seek mandamus or structural interdict and invalidation. Then the other application that you can make judicial review application pursuant to section 6 plus order 53 of the civil procedure rules that provides for judicial review procedures. This is used when you are challenging an administrative decision or action for illegality or irrationality or procedural unfairness contrary to the advisory opinion. Then the orders that you will seek in the JR, you will seek these orders on certiorari to quash, prohibition to stop, and mandamus to compel. Then lastly, you can also institute contempt proceedings. This is used where there is an existing court order or decree made in your later petition or JR suit and the respondent disobeys it. So remember that you cannot cite contempt purely for ignoring an advisory opinion unless there is a specific enforceable order directed at the parties. So that is it. That is how you move court in enforcement of an advisory opinion from the Supreme Court. What are the objectives of the Virtual Assets Services Providers Act? This was testing on whether a candidate had gone through the Virtual Assets Services Providers Act. Has any one of us gone through the Act itself? I've not managed to open the same. Let me open. So the primary objective of the Virtual Assets Services Providers Act is to establish a comprehensive legal and regulatory framework for digital assets businesses. So where you have licensing and oversight, you have consumer and investor protection, you have combating financial crimes, you have market integrity, and you have regulatory clarity. Those are the core objectives of the Act. Define public interest. Any person? What is public interest? Yes, proceed.
Public
Public interest is, I'd say that this is, let's say, for instance, let's say the Bill of Rights. Talking about the Bill of Rights, like it's something that affects a larger majority of a population within a state. So, public interest is a stake that a larger population in a country have in a matter, such that if you tamper with that matter, either positively or negatively, it will likely affect a wider population. So that's by definition. But just to return to just refer you back, I just needed a clarification on the adversarial opinion part on how to make the application. I think Albert said something like you file something, a reference or what?
Albert, you can clarify the same. Albert?
Yes.
So from
Yes, I can.
Okay.
So basically, you file. There is a formal application known as a reference. In that reference, now you seek what area of law you want the Supreme Court to give an opinion on or clarify. Then that reference is supported by a supporting affidavit, explaining the facts and the grounds which have led to you now filing the reference and exactly what you want the Supreme Court to clarify. So that is how you move the court. I think it's provided under Article 163.3, and I'm yet to find out the exact form, but it is a form known as a reference. I'll share the form so that we can all see the structure if I get it. Then it is supported by a supporting affidavit.
Thank you, Albert, for that clarification. So, Mr. Chadwick had also attempted on what amounts to public interest, So public interest is the collective welfare of the public or a significant section of it. On the interest, where the interests in lawful or accountable governance and protection of public resources and rights will supersede as opposed to a party's private advantage. So even the angle of significant section of it can amount to public interest, not generally the collective welfare in all the public, even a significant section. That was an open-ended question. What are the differences between filing an application for stay at the Court of Appeal versus the High Court? What are the considerations made by judges in the two stages? What are the differences between filing an application for stay at the Court of Appeal versus the High Court, and the considerations to be made by the judges? This one is also technical. It expects a student ought to have mastered both the Court of Appeal rules, Rule 52B, and then the High Court pursuant to Order 42, Rule 6 of the Civil Procedure Rules. What is the marking scheme? This appears, anyone can attempt. This one can also be asked in our capacity. You can also be told to draft an application under the civil litigation unit, where a person intends to seek stay pending an appeal. Any attempt? Okay, what is the marking scheme? Stay in the High Court is governed by Order 42, Rule 6. The test to be applied: do you have substantial loss? Have you approached court with no delay? And are you willing to furnish security? That is Order 42, Rule 6. Substantial loss, no delay, security. Stay in the Court of Appeal is under Rule 52B on Court of Appeal rules. You have to show you have an arguable appeal, plus if the appeal is not, if you have not been granted this stay, your appeal will have a nugatory effect. So the tests are different, and the Court of Appeals jurisdiction is original and discretionary, not an appeal from the High Court's discretion. Okay, so the Courts of Appeal jurisdiction is original and discretionary. Okay, but for the other one, an appeal rising from the subordinate courts. High Court stay pending appeal governing rules. Order 42, Rule 6, statutory test is expressly stated: substantial loss, no unreasonable delay, and willingness to furnish security. Court of Appeal has power to grant stay or injunction or stay of proceedings once a notice of appeal is lodged. Okay? Judicial interpretation, twin principles that you ought to state. For this one, I'll have to go to the decision that has tried to explain for the Court of Appeal angle. So if you read the case of Watunu and another versus Wamutoro 2024, the Court of Appeal dismissed the application for stay of execution because the applicants failed to satisfy the two mandatory principles under Rule 52B of the Court of Appeal rules. Specifically, the applicants did not demonstrate that their intended appeal was arguable, as they made no averment or submission on any arguable ground, nor did they annex a draft memorandum of appeal. The applicant's general assertion that the decretal amount was enormous was insufficient to establish an arguable appeal. Since the first limb was not satisfied, the court found it unnecessary to consider whether the appeal would be rendered nugatory. The court also clarified that Order 42, Rule 6 of the Civil Procedure Rules does not apply to the Court of Appeal, and both parties had misapplied the law in their submissions. Consequently, the application was dismissed with cost to the respondents. So if you are attentive in our sessions, remember there was a debate that had arose in the professional ethics question where the advocate had tried to force a 5.2b application pursuant to the Supreme Court scenario, and Albert duly said that a client can be given cost pursuant to that action, and we have seen clearly there is a decision where the costs were awarded, and this was in support that there was professional negligence and the advocate had failed to that extent. So nugatory limb commonly turns on refundability and reversibility. Burden can shift once applicant shows reasonable fear of non-recovery. There is a decision to this so that we can understand. ICA Lion Assurance Company Limited versus Waigwa 2023. The court found that the applicants had demonstrated an arguable appeal as their draft memorandum of appeal raised grounds that were not frivolous. On the nugatory aspect, the court held that although the respondent was not a man of straw, his monthly income was too low compared to the decretal sum of 2.6 billion, and his reliance on his sister's undertaking was insufficient as she was not a party to the suit. The applicant's apprehension about recovery was therefore justified. The court concluded that the requirements for stay under 5.2b were met and granted the stay of execution conditional upon the applicants depositing the discretal sum in a joint interest earning account in the names of the parties advocates within 30 days. So what are the key differences? The way I told you to always break down so that an examiner can see what you are doing. You state the source and nature of jurisdiction. The High Court, it is a discretionary power under Order 42 Rule 6 to stay its decree or order pending appeal, while on the other hand, the Court of Appeal, it is discretionary original jurisdiction under Rule 5.2b, not reviewing the High Court stay ruling. So it is not as a right. It is an original jurisdiction that is under a discretion of the Court of Appeal. What is the threshold test for both? We saw Order 42 Rule 6 in the High Court. You have to show substantial loss if stay is refused. You have to show promptness. You have not approached court with unreasonable delay. You have to show that security for due performance is ready to be deposited. Then Court of Appeal, Rule 5.2b, you have to show you have an arguable appeal, at least one bona fide ground, and the same is not frivolous. Then the nugatory effect, if stay is refused, e.g. decree is irreversible, respondents cannot refund, or subject matter will be destroyed. We have seen the Court of Appeal applying this test as in a conjunctive manner, where if you pass in one test and fail in the other, then your application will still have failed. Evidence focus, the High Court, affidavits on substantial loss, execution risk, explanation of delay, and a concrete security proposal, while on the Court of Appeal, you annex draft memorandum of appeal, you show arguable points, demonstrate nugatory risk on refundability, irreversibility, and public process timelines. Then procedure and sequence. You may seek stay first in the High Court, but Court of Appeal can still entertain it regardless, depending on circumstances. Practically, courts expect you to move fast in both forums to avoid execution. Okay, because for the Court of Appeal one, that is an original discretion power. So the other key takeaway that I want you to take note is whether you are, when you are filing this 5.2b application, is it a must you could have filed a notice of appeal, or you can still seek a Rule 5.2b? Can you apply 5.2b where there is no notice of appeal? That is a question that I also posed to you as I Google the same, where the notice of appeal is not lodged. So I'm finding numerous sources. Let me summarize the easier one to interpret. So the answer is no. A Rule 52B application cannot be entertained unless a notice of appeal has been lodged. Without a valid notice of appeal, the Court of Appeal has no jurisdiction under 52B. So if there is an examiner who wants to confuse you, they will say that this person has not yet filed a notice of appeal and the advocate still has made an application under 52B before the Court of Appeal, and at the same time has filed a notice of has at the same time filed a stay pending execution at the High Court. Remember, the one that will be cured is the one that has been filed in the High Court as compared to the one that is filed in the Court of Appeal. So what is the governing rule? Rule 52B is expressly triggered where a notice of appeal has been lodged. This is directly interpreted under Rule 5 of the Court of Appeal rules. So notice of appeal is lodged in the Superior Court within the prescribed times. Rule 77 of the Court of Appeal rules. So if there is no notice of appeal, no 52B jurisdiction, and the application is struck out. Another question, what is the place of woman-to-woman marriages in Kenya versus the Article 45 of the Supreme Court of Kenya? Who bears parental responsibility for children born from such marriages? Another technical perspective, any attempt, what is the place of woman-to-woman marriages in Kenya versus Article 45 of the Constitution of Kenya, and who bears the parental responsibility for children born from such marriages? Any attempt? Any attempt? Do the women jointly have the parental responsibility, or there must be a man for parental responsibility to apply? That was a reverse psychology there. So the answer, woman-to-woman marriage exists in Kenyan practice only as a customary institution, not as same-sex marriage protected by Article 45. It is recognized mainly for succession, where approved as a valid customary marriage. Parental responsibility for children is borne by the child's biological parents, but a spouse, step-parent in that household can acquire parental responsibility under the Children Act and by conduct or through court order. So, marriage under the Constitution, Article 45(2) of the Constitution of Kenya, provides that marriage is between adults of the opposite sex. While customary marriages still exist in statute, customary marriage is celebrated by the customs of the parties and communities. This is pursuant to Section 43(1) of the Marriage Act. So, parental responsibility. Parents have equal parental responsibility pursuant to Section 32 of the Children's Act. This is the new statute in place. And a parent spouse also exercises parental responsibility inclusive of a step-parent responsibility, Section 34(6) of the Children's Act. So courts have recognized customary woman-to-woman marriages, e.g. in Nandi, Kipsigis, and Giriama communities for succession where customary rights are proved. It is treated as a cultural or customary institution rather than constitutional marriage under Article 45(2). We have also seen decisions to that effect. If you read the case of Leah Cherotich, Soy versus Tekla Chesang Rebecca, that is an authority to that question. So remember the question that was asking whether it is relevant to register customary marriages. So it will also be relevant to register woman-to-woman marriages because the same also applies to customary marriages, or are these setups applicable where the man is deceased and then two ladies now come up together to make sure that the company lineage is the family lineage is not divided. So you see, if you want to register these customary marriages, then the bracket will be broader but as we said, that is the position of the law. It requires registration for them to be recognized. The other question before you is question number 72. Article 259(1) of the of the Constitution of Kenya should be interpreted in a manner that promotes development of the law and good governance. Article 21, in applying the Bill of Rights, a court should develop the law to the extent that it does give effect to a right or a fundamental freedom. How does the High Court exercise its power to develop the law? Give various instances. So Article 259 should be interpreted in a manner that promotes the development of the law. So Article 21, in applying the Bill of Rights, a court should develop the law to the extent that it gives effect to a right or a fundamental freedom. How does the High Court exercise its power to develop the law? So any attempt, but this one appears to be practical. The High Court develops the law mainly by purposive constitutional interpretation, and number 2, through recognizing and enforcing new dimensions of rights through remedies, and 3, crafting implementation tools, e.g. structural interdicts and mandamus to make rights effective and improve governance. Article 259(1) of the Constitution of Kenya interprets the Constitution in a manner that promotes its purpose and values and advances the rule of law and human rights and contributes to good governance. Article 21(3) of the Constitution of Kenya, in applying the Bill of Rights, a court shall develop the law to the extent that it does not give effect to a right or freedom that and adapt the interpretation that most favors enforcement. So those are the enabling provisions that give the High Court the power to develop the law through development of remedies such as structural interdicts and supervision to make rights real. Proceed, anyone who has raised up their hand.
I was thinking about Article 159 as well. To be included there. Article 159 on overriding objectives that now will add up to how the High Court uses to develop the law in terms of the procedural technicalities, etc. So it's also a point that we can add there.
Thank you, Mr. Chedwick, for that. Indeed, that amounts to an answer to this question too. Thank you. So, next question before you. What is the constitutional doctrine of severance interpretive tool used by the High Court when an act is challenged as unconstitutional? That is also a technical question. What is the constitutional doctrine of severance as an interpretive tool used by the High Court when an act is challenged as unconstitutional? The constitutional doctrine of severance or severability lets the High Court strike down only the unconstitutional part of a statute and preserve the rest, so long as the remainder can function coherently and Parliament's core purpose can still be achieved without the offending portion. Okay, so the High Court the Constitution is supreme. Invalidity is to the extent of inconsistency. Article 2(4) of the Constitution of Kenya. So severance operationalizes this by avoiding wholesale invalidation where a narrower remedy cures the defect. Okay, so the Court of Appeal, affirming the approach applied in constitutional adjudication, described severance as requiring courts to declare only the offending portion unconstitutional and preserve the rest where possible, and only invalidate the whole statute where the valid and invalid parts are inextricably intertwined. This was seen in the decision known as the National Assembly versus Katiba Institute and 6 others, 2023 decision. That is the decision that gave rise to this doctrine on constitutional doctrine of severance. Doctrine of reading in. Kuna doctrine mingi that the panel had retrieved from various decisions over the years. Does anyone know of the doctrine of reading in? Before we read the marking scheme. So the marking scheme reads that reading in is a constitutional remedy or interpretive technique where the court cures an unconstitutional omission or under-inclusive wording by adding words to the impugned provision so it becomes constitutional. Instead of striking it down, this is used sparingly because it risks judicial legislation. It flows from the High Court's remedial power to grant appropriate relief in constitutional litigation pursuant to Article 23(3) of the Constitution of Kenya and the interpretative duty to develop the law pursuant to Article 23 and 259 and 159 of the Constitution of Kenya. So the Court of Appeal upheld and discussed the High Court's reading in approach. The High Court had read words into Section 18(1) of the Vetting of Judges and Magistrate Act to confine the board's mandate to the institutional permitted period. So for us to understand, let us take the ratio decidendi on this decision. The decision is known as Judges and Magistrates Vetting Board and Attorney General versus the Kenya Magistrate and Judges Association 2014. The Court of Appeal held that the vetting of judges and magistrates by the Judges and Magistrates Vetting Board is a transitional mechanism intended to address conduct up to the effective date of the Constitution of Kenya 2010. The court found that the relevant constitutional and statutory provisions, when interpreted contextually and purposively, restrict the vetting board's mandate to complaints arising or pending before the effective date. Complaints arising after the effective date fall exclusively within the jurisdiction of the JSC Commission as provided by Articles 168 and 172 of the Constitution. The court rejected the argument that the vetting board and the commission have concurrent jurisdiction over post-effective date complaints. Emphasizing the need for certainty and harmony in constitutional institutions, the court also upheld the High Court's use of reading in as a legitimate constitutional remedy to clarify the statutory mandate of the vetting board, though it noted that a purposive interpretation alone would have sufficed. The doctrine of res judicata was found inapplicable as the issues in the present case were distinct from those in prior litigation. Accordingly, the appeal was dismissed and each party was ordered to bear their own course. So as a takeaway, the High Court had read words into Section 18(1) of the Vetting of Judges and Magistrate Act to confine the board's mandate to the constitutionally permitted period. So courts emphasize that remedies like reading in or severance must not amount to rewriting legislations beyond what is necessary to cure the constitutional defect. So that is a takeaway from the National Assembly versus Katiba Institute and 6 others 2023 decision. So we can, the meeting will end exactly at 4 p.m. so that we salvage the weekend in other duties. So we have 1 hour to go. In part question 75. Question 75. In the retired constitution, the CPC section 87A, DPP could terminate a case at any stage. Has this position changed in the new constitution? Any attempt, because it is under criminal litigation, a question? Any attempt from any member? Okay, attempt.
I think it has not changed since it's still being used. I remember the recent case of the one for corruption of Zakaria Okotobado. The prosecution agreed to withdraw under 87A, so I think it's still applicable up to this era.
Any other attempt? Because you have because it was a yes or no question, na hakuna kusema there is an intermediary. Nimesikia mtu mwingine ameinua mkono.
Yes, it's me. Okay, I think it has changed, but I have a reservation based on the general statement, the general nature of the statement of that question. It's saying in the retired constitution, CPC section 87, the DPP could terminate a case at any stage. So I'm saying, I acknowledge that the DPP has the power to terminate a case, but again, it's not at any stage, because you see the general criminal litigation process, it commences from right from the time a complaint is lodged up to the time a person is convicted and sentenced, or rather acquitted for that purpose. So I'm wondering if the same could apply. Can the DPP exercise his power to terminate a case at the stage where a determination has already been made, the court has already convicted someone, or maybe sentence has already been given? I think that is the extent to which I do not agree with that statement. He has the power to terminate a case, but not at any stage. So perhaps my answer will be yes, they have the power to terminate, so long as it is before either hearing or delivery of the determination, even though I'm not sure. Just a quick shot from my end.
Albert, while you are on your feet, allow me to say something. Wakati nilikuwa naangalia hizi interview, there is a person aliappear in the panel akasema that I am a tractor, and once given this job, I'll perform as a tractor. So one of the panelist member akasema, if you are a tractor, let us give you tractor questions. So in this question, Albert, give a yes or no answer. In the retired constitution, the CPC section 87A provided that the DPP could terminate a case at any stage. Has this position changed in the new constitution? A yes or no answer. These are some tractor questions.
But the problem with that question is, it is impossible for the DPP to terminate a case at any stage. What stages are we talking about here? Because any stage beyond hearing, beyond determination of the case and sentencing, the DPP has very little input on that case.
Haya, let me reframe. I can reframe the question. I don't want you to avoid this question. Now, let me remove the confusing element. In the previous laws, the DPP had powers to terminate a case at any stage. By any stage, I mean the criminal trial process, because you have the knowledge spanning around your waist when it comes to the criminal process. Now, I have tried as much as possible to rephrase the question. Now, answer the question. Is this still the position to date?
Let me allow Daktari to give him his thoughts, then I give mine.
Sawa, Daktari?
All right. I think even in still the practice is going on, because even in this new constitution, as we will see, even when for example, the new DPP, when they came in, he how do you put it in English? He removed cases that had already proceeded to trial. For example, there were even corruption cases. Even look at the Gachagua case that was already had even proceeded, and there are cases even in this year that he has terminated. But in some latest cases, the High Court has indicated that you cannot terminate a case without the permission of the court. So this is the current position, although the DPP has done it without the permission of the court. But nowadays, the court is now strong that it should not be terminated without the permission of the court. And also we have activists who are challenging the termination of cases in court.
Thank you, Dr. for the last segment of your answer, because the position has completely changed. The answer is yes, the position has changed. The 2010 Constitution changed it. The DPP can no longer terminate at any stage purely as of right. Discontinuance or withdrawal now requires the court's permission or consent, and the court must police public interest and administration of justice. Governing rules. Withdrawal in subordinate courts. Withdrawal is still available before judgment, but it is anchored on the court's consent and has different consequences depending on the stage. Discharge before defense and an acquittal after defense is called. If you read directly Section 87 of the Criminal Procedure Code, let me read in verbatim. In a trial before a subordinate court, a public prosecutor, it has been underlined with some dots, may, with the consent of the court or on the instructions of the Director of Public Prosecutions, the same has an asterisk, okay? On the instructions of the DPP has an asterisk on top. At any time before judgment is pronounced, withdraw from the prosecution of any person, and upon withdrawal, if it is made before the accused person is called upon to make his defense, he shall be discharged. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on account of the same facts, and B, if it is made after the accused person is called upon to make his defense, he shall be acquitted. What is the meaning of the asterisk? If you look downwards, there is a Statute Law Miscellaneous Amendment Act of 2012 that was used to, sorry, you can speak.
I'll finish first.
Okay, sir. Then another key takeaway that we can see is a nolle prosequi under the Criminal Procedure Code. The DPP may enter a nolle prosequi at any stage before verdict or judgment. The accused is discharged but can be charged again, still subject to constitutional consent of court requirement post-2010. Statutory restatement of the constitutional requirement, DPP may discontinue with the permission of the court. This is provided for under Section 25 of the Office of the Director of Public Prosecutions Act. If you read Section 25 of the ODPP Act, discontinuing of criminal proceedings, the Director may, with the permission of the court, discontinue a prosecution commenced by the Director, any person or authority at any stage before delivery of judgment. Pending the permission by the court in accordance with subsection 1, the Director may apply orally or in writing to the court for a stay of proceedings with a view that such proceedings may be taken over by the Director to prevent and avoid abuse of the legal process and to protect the public interest. 3. Nothing in this subsection prevents the Director from continuing to conduct proceedings in the name of the person or authority that instituted those proceedings. Okay? Judicial interpretation. Court's consent is real and stage matters. Where withdrawal is sought after the accused is placed on defense, the proper consequence is acquittal and not a discharge, and the trial court must be satisfied on reasons. This is provided for under Article 157(8) of the Constitution of Kenya. Withdrawal under Section 87A is discretionary and must be judicious. Trial court can allow withdrawal before judgment, but it must be an exercised discretion. Old position was that prosecutorial discontinuance was treated as largely executive control. The new position is that discontinuance or withdrawal is constitutionally and statutorily court control. You must move the court considers the reason, public interest and justice, and the stage determines whether the accused is discharged or acquitted pursuant to Section 87 of the CPC. What is the takeaway? DPP still initiates withdrawal but cannot unilaterally terminate proceedings in open court without the court's permission and recorded reasons. That is the position, Albert. You had raised your hand.
Yes, thank you. I've appreciated the shift from the repeal constitution and the current constitution to the extent that in the repeal constitution, the DPP could do that without prior permission or relief from the court. And now the shift to the current constitution, or the constitution rather, is that for the DPP to exercise that authority, he or she must seek leave of the court, right? Now, the only problem I had with the question is that it was too vague, to the extent that it says whether, it was question
75.
75, whether the DPP could terminate a case at any stage. I only had a problem with at any stage. The DPP cannot terminate a case at any stage. The DPP can terminate a case at any stage so long as judgment has not yet been delivered. And remember, in the, as you had said, in the criminal process, the criminal process is very long. It starts right from a time a complaint is lodged to sentencing, right?
Mm-hmm.
So it's between a complaint, when a complaint is lodged to when a judgment is delivered, that is when the DPP can exercise that discretion there to terminate or maybe to discontinue the prosecution. But beyond that, they can't do. So that is the only problem I had with this question. It was too vague.
Okay, so we allow sparingly your avoidance. It can be justified on that angle. So if you read question number 76, suppose you have an appeal case where the DPP states that they filed an application for withdrawal of charges, but the same was denied. What are the considerations you will make when making a determination one way or the other? So this also appears to be vague in a way, because this was basically a transcription from the actual questions, the way they were being asked directly from the candidate, and they basically were dependent on the answer that he or she had given on the previous question. So this one I can read out the answer directly because it appears to be confusing, but from the answers we will analyze and hear the approach that the question wanted. So
I think this question was directed to a member of the bench, right?
Was it to the member of the bench? Yes, it is a candidate. It was a candidate.
Oh, yes. So I'm saying, given the answer we are giving from a judge's perspective, what considerations you make in making a determination?
True. As a judge now. On appeal or revision, you uphold or overturn the refusal to withdraw by asking one question. Did the trial court exercise its discretion under Article 157(8) and Section 87 of the Criminal Procedure Code judiciously, i.e., on the reasons tied to public interest, administration of justice, victims' rights, and fair trial, rather than whimsically? So the governing rules is Section 87 of the Criminal Procedure Code and Section 25 of the ODPP Act. So judicial interpretation in this question is that the trial court may properly refuse a withdrawal where reasons are inadequate, settlement does not bind all parties, or withdrawal will prejudice justice. The High Court will not interfere if discretion was properly exercised. This was used in the case of Edwin Sironka Olon Chike versus the Republic, a 2018 decision. The other angle that you can take away is that trial court decision is reversible where it is unreasoned or whimsical. A refusal must be supported by reasons, otherwise it's an improper exercise of discretion. This is the case of Republic versus Kennedy on Sarigo Sebe 2019 decision. Lastly, court is not a rubber stamp. It must be satisfied withdrawal is justified and does not undermine public interest or justice or ignore victims. This is the case of Ahmed Rashid Jabril versus the Republic 2020 decision. So what are the considerations to determine on allow versus deny? What will you analyze on appeal? Number one, stage of proceedings and the consequence. Is withdrawal sought before the accused is put on defense? This will lead to a discharge, okay, and recharge if possible, or after the accused has given out his defense, then this will result to an acquittal, and this will bar any retrial. This is provided for under section 87. Then also consider the later the stage, the heavier the justification required. The more you progress towards a judgment, the heavier the justification will be required. That is one stage of proceedings as a factor that you will consider. Then the other factor that you will consider is quality of reasons placed before the court. What is the evidential insufficiency? So do you have key witnesses unavailable despite efforts? Do you have new exculpatory evidence? Do you have public interest considerations? How serious the offense was? Do you need? Was there any need for deterrence? Avoiding abuse of process, withdrawal not being used to reset a failing case. Okay. Then 3, a victim or complainant participation and prejudice. Was the complainant or victim informed and heard where appropriate, as was seen in the case of Ahmed Rashid Jabril? And would withdrawal defeat legitimate victim interest, e.g. multiple complainants or counts or unresolved counts? This was exercised in the case of Republic versus Kanyenze Alliance Pentagon 2024. Then fair trial rights or oppression risk to accused. Will the withdrawal plus likely recharge become oppressive, or will it be used to delay or repetitive arrests amounting to abuse? This was seen in the case of Titus Kome Kubai versus Republic 2015. Lastly is whether the trial court gave reasons and exercised discretion judicially. So this is seen if the magistrate gave coherent reasons tied to justice or public interest. Appellate court should be slow to interfere. If refusal or approval was unreasoned, capricious, or ignored material factors, then the High Court has to interfere, as was applied in Kennedy Onsarigo decision versus the Republic. So key takeaways is you have to check the stage of the proceedings, you have to see the quality of the reasons placed before the court, you have to consider the victim or complainant participation and prejudice, you have to check on fair trial rights, and then you have to check whether the trial court gave reasons and exercised its discretion judiciously. So this the question number 77 will be the last question because it is still tied to the DPP. So because the DPP is in charge of prosecution, can he take over a matter that is in the court martial, and why? This will be the last question. Anyone who can attempt, because the DPP is the one in charge of prosecution, can he take over a matter that is in the court martial, and why? Any attempt? Any attempt before I read out the answers? So if the silence continues, then I presume that the answer is ripe. So the answer is no. The DPP cannot take over and prosecute a case before a court martial because Article 157 of the Constitution expressly excludes court martials. Prosecutions at court martial are the mandate of the Director of Military Prosecutions under the Kenya Defence Forces Act. The DPP's role is confined to civilian courts and to appeals from court martial, where the KDF Act gives him a standing. Okay, so the only role that the DPP can be used to maybe secure the standard, the local standard in the matter is where there is an appeal from the court martial because the KDF Act gives him the standing. What are the enabling rules? The DPP power excludes court martials. The DPP may institute or take over criminal proceedings before any court other than a court martial. That is directly written under Section 5(1)(b) of the Office of the Director of Public Prosecutions Act. And the other key takeaway is that the court-martial prosecutions are for the Director of Military Prosecutions. The Director of Military Prosecutions shall undertake prosecutions at a court-martial, and notwithstanding Section 157, has power to decide whether to prosecute where the accused elects court-martial, etc. This is provided for under Section 213 of the Kenya Defence Forces Act. If you read Section 186 of the Kenya Defences Act, but the DPP can appeal court-martial outcomes. The DPP may appeal to the High Court and upwards against sentence and in specified circumstances, acquittal. So, court's interpretation. The High Court has treated the DPP's mandate as before any court other than a court-martial, and the Director of Military Prosecutions mandate as limited to prosecutions within the court-martial. This is seen in the case of Pongiso versus Republic 2022. Then another takeaway is that the High Court reaffirmed the same statutory and constitutional separation in that the DPP prosecutes in civil courts while the court-martial prosecutions are for the Military Prosecution Office. This is the case of Mugure versus the Attorney General and 3 others 2024 decision. So those are the key takeaways that the panel was expecting from a candidate to state. So basically, at least at this point, we can say we have identified the tricky questions, we have also identified the hard questions, we have also identified matters arising from the questions, we have also identified that some questions are directly related to the judiciary, and basically the various tests that a student ought to take note of. So hizi maswali zina expand our brains and pia zinatufunza current affairs at a go. So allow me to now put the floor to any member who has a comment, because we are only left with 20 minutes so that we can save our weekend. Any comments to make? Because I have already explained to you the structure that we will be applying in these oral questions. The next step, like tomorrow, we will deal with, we can do a combination of the JSC and a course outline perspective, because I really want us to go through questions emanating from a course outline, because inakuanga ngumu sana pia for students to go through a course outline. That is one fact that I also came to know. In fact, the examiner have been told that kindly set questions from the course outline. Remember, there was a joint committee effort this year between the KSL and CLE, where students walikuwa na complained whatever we are tunaletewa kwa exams hatujafunzwa. So maybe to counter that, the examiners will directly lift the questions from the course outline. So these questions will help us so that we be at par with the course outline. So that is one. The criminal litigation is ready. We will start with the criminal litigation questions tomorrow hapo majioni, because I said it is not proper for us to do substantive areas watu wakiwa wamechoka jioni, but for orals ni vitu zinarukaruka, maybe at times common sense questions nini, so you can listen or do it even if you are tired as much as possible. So tomorrow we will combine criminal litigation element, then we do a small tu kadogo, maybe one of the member tumalizie hizi za section number 77 all the way to 89, because in as much as we don't want to do JSC questions, remember pia our examiners are individuals like us. Maybe this document ya JSC imecirculate in their group, so maybe these are the questions they wanaenda kutoa hapa, kuna kutoa pia maswali kwingine. So let us prepare pia tumalize hizi maswali juu na pages 30. We are currently under page 4, so you can imagine if we are in a position to kumaliza hizi swali zote, hakuna swali tutaogopa for that orals. alafu tukicombine na course outline. So up to this point I leave the session to the members. So thank you so much. I have seen your appreciation in form of reactions. So if there is no other contribution or question, then I can duly mark this session number 2 as closed and upload the same to the YouTube channel for record purposes. In fact, hata exams kikaribia, hiyo siku zenye tuko na leave huko, utapata tu unahitaji tu hii inaitwaje, earpod, unasikiza tu hizi vitu juu at the end of the day hizi vitu ni very substantive na ni very critical. In fact, hata I'm in a position where if we have duly gone through all the statutes, landmark statutes, decisions, matters arising, orals, tumefanya our best in group works, then one way or another we fail in one unit, I'm willing to recede, because the main motive was not to pass, but the main motive was for us to understand what happens in the ground as compared to reading notes hivi. So that is something that I've also just nimekubali tu by nature, provided we give our best. So thank you guys for your contributions and attendance. Let me mark this session as closed. Thanks so much.